Won't let me say too much about her, but if I were, we'd be here for like an hour because she has that many accolades. She speaks all over the place. She is board certified in Texas criminal appellate law. So we're very happy to have Jani Maselli Wood.
All right, hello, can you all hear me? Welcome. Do I have any Hamilton fans here? We have a few. Well, I'm about to change your life, more or less. And this comes after 20 plus many years of doing appellate work. And I've come to some realizations. And before I went to the public defender's office, and I've been there 6.5 years, I did a lot of different things. I did writs, I did capital federal habeas, I did all sorts of things. But I got hired at the PD's office and I do direct appeals. It's a lonely world out there. And I assume most of you are all trial attorneys, right? Yes. I've got some good news for you and some bad news. Okay, the good news is that you can change your life by learning a few tricks that I'm going to show you. The bad news is that a lot of times the people who aren't here are the ones who get the one-word verdict, and then I get the case, and there are absolutely no objections to work with. And I'm going to tell you right now, relevance, yeah, no. Non-responsive, no. So I'm going to tell you what to say. You should have gotten a Dropbox link if you registered, and I have a paper in there, which is for you all. I got to find my paper, and I want you to print it out if you like, and it has every objection you can make. And it has the statute, and it has the constitutional provision, the federal and state constitutional provision. How many of you have read the Texas Constitution? I love it. Well, for those who haven't, it's on the back of the paper. Because I want you to change the world. I want you to make my life better. And again, it really is all about me. Not really. It's all about the Astros were up from what I just checked. Not that I was checking during Mark's speech at all. I couldn't believe, yesterday I taught at U of H during the game, and today I'm here. I thought, this is not good. But anyway, we're going to talk about preservation of error. We're going to talk about Hamilton. We're going to talk about making your life better and my life easier, and making the judges' lives like blowing their mind, because you're not going to say anything like relevance again. They're not going to know what you're talking about, all right? So, you have one shot. As Hamilton said, I'm not going to throw away my shot. That is so true. You have one shot to object. What happens if you wait too long? Waived. So don't wait. Don't lose your shot. If you're not sure to object, you know what I'm going to tell you to do? Object. Right. It's not going to hurt you. And before I went to the PDs, I had a wonderful, great business doing writs. You know, when I would call maybe one or two of you, you would not take my call. I get it. But I would ask people, well, why didn't you object? And they say, well, that's not how I do things. I get it. But I want you to change the way you do things. I want you on your feet. I want you objecting. I want it to be all about you. You're the center. The judge is going to be scared by you when you start throwing this stuff around. Believe me. And then when I read your records, I'm not going to be crying and explaining to interns, well, there's 8 relevance objections. What should we write on? None of those. None of those. So you're going to object. You're going to make a bill, If they don't let your evidence in, you're going to get it on the record. If it's not on the record, if our favorite court reporter is not typing, no bueno. See, yo hablo español poquito. No bueno. It's got to be on the record. And that's why if you have a bill that you have it all typed up and you want to get it in and the judge says, well, I'm not going to allow that in. Judge, I'd just like to put this part of the record. Oh, that is beautiful. When I see a bill, it's awesome. I'll also tell you something. If you want something that you don't want the state to see or they don't want you to see, we had a case in Judge Bradley's court about some DA's emails, okay? And they didn't want us to see them because they're work product, but I thought there was Brady in there. So I said, well, Judge, why don't you just seal them for the appellate record? That's fine, because you know what? I spent 2 years at the Court of Criminal Appeals, and you know what we love? Sealed envelopes. Love it. Oh, this is sealed? What's in there? Really? They were very boring up there. You don't see people, but sealed envelopes and tape recordings? Great. All right. So you have one shot. Rules for objecting. This is all from law school, but if you don't know where it's found, it's in the Texas Rules of Appellate Procedure. And for those of you who are trial attorneys, you're thinking, well, I don't have to deal with the trap rules. You do. Because if you lose, this is what it all comes down to. And they're called traps for a reason. Timely, get on your feet. Specific. I will tell you that the Court of Criminal Appeals in the last 2 years has become the Houdini of denying cases because it wasn't quite specific enough. So if you think you've said enough, say a little more. Because they're like, well, we're not really sure. So be specific. Especially, do any of you do DWI? Some of you? They're probably all at some advanced DWI right now, or at the game in the front row. I'm kidding. So be specific. And ultimately, what do you want? A ruling. Do you want that ruling to go for you? You're thinking, yeah, I want him to rule for me. And I'm thinking, no, we do not want the judge to rule for us. Unless it's something serious about getting some evidence in that you really need. But a lot of this, as Racehorse Haynes said many years ago, it's putting your hickey in the record. If you don't do that, I can't do anything to help your client afterwards. So it all depends on you. So when I get accolades for being, she won this case, sometimes it's me because I've done a motion for new trial and put in my own hickey. Most times it's y'all who win it for the appeal. So don't forget that. You guys do it. So for Hamilton, he tried the first murder case in our new country after we had the Constitution. He practiced the law just like you, practically perfected it. He's seen injustice in the world and he's corrected it. That's what you all are doing, right? A little bit of injustice. Being an appellate attorney, I don't go to court very often. I don't know most of you. I love seeing your work, but I will say I've been doing a few bail hearings, and that is one of the things where you get a reward immediately. Like the judge gives your guy a personal bond. I feel like I've won a capital murder appeal. It's like, oh, I got a personal bond. So anyway, but this is us. We're correcting injustice. Okay, here's the key to all. This is the key to you changing your world, the Constitution. That's the key. See how easy it is? And that's the key because a hearsay objection on appeal is basically meaningless. But a confrontation objection is meaningful. Did you all know that? Because most of the records I read, people have no idea. Relevance. We're not going to say relevance. You know why? I've never read a case where relevance has won on appeal. And again, we're talking about me, and what I'm trying to do here is win these cases after the jury erroneously made a decision. So instead of saying relevance, say, Judge, I object. This is denying him due process and a fair trial by letting in this evidence that, You know, he's entitled to a fair trial, not all this other evidence coming in. Is that hard to do? You know why it's not hard? Because you're going to have this in your book. And if you ever forget what to say, you're like, oh, it's the heat of battle. Look, I get it. Sometimes at oral argument, like I'm frozen. Just due process. Due process. Due process. Extraneous offenses, denying him due process and a fair trial. As Casey said earlier, you got the whole bouquet of the constitutional rights. Use them. Use them. Because when you say hearsay, relevance, this violates 404B, this is what the Court of Appeals says. This is great. I can use one of my other affirmances. Let me get an intern to write this. Boom, you lose. And I'm going to tell you why you lose. All right, here's some more. Have any of you ever said, oh, objection leading? You don't have to shake your heads because my eyes are closed, but I know it's happened because I read it a lot. And my law students read it and they get very upset. There is some leading going on here. Okay. Yeah, it's meaningless. It's really meaningless. I had one young lawyer who I spoke to after I read his record, and he was a fighter. And I said, all these objections are meaningless. And in his sweet young face, he said, but that's what they taught me in law school. I'm sorry. So we're going to change our world right now. We're not going to ever say, objection leading, objection due process. The state's giving them the answer, right? Isn't that what leading is? I can't write anything on leading, but I can write something on that. Not argumentative, not non-responsive. It's due process. The state's doing this. They're denying my client a fair trial. And look, I realize you're thinking, she's insane. And that may be true. That may be true. However, if I were to read a record where some of you made objections like this, I will take you to lunch. I will take you to lunch. It has to be relatively inexpensive. I am a public defender, but we will go to lunch. I've written letters to lawyers before. Bob Loper and Jimmy Ortiz, I read a record they wrote that was so beautiful, I'm not kidding, it brought tears to my eyes. Really, I wrote them, and I said to them, this client has had bad luck his whole life until he hit the lottery and got you guys, because it was that beautiful. So I have read beautiful records. You know, I will say Eric Davis, I don't know if he's here, the problem with an Eric Davis record is there's so many things that are preserved, I have to pick and choose. I mean, that's a good problem to have. You know, Skip Cornelius over there, he had a record that was so beautiful that I ended up litigating it for 5 years and wrote 14 briefs. So thank you. Thank you. But you know, goofballs like me love that because I like to play every day. All right, so here's why it matters. This is the trap rule, 44.2. If any of you suffer from insomnia, you might open this book and this section and you will go off to sleep immediately. So if you make the error under the Constitution, so if the appellate record in a criminal case reveals constitutional error that is subject to harmless error review, the Court of Appeals must reverse a judgment of conviction unless the court determines beyond a reasonable doubt that the error did not contribute to the conviction or punishment. That's a pretty good standard, isn't it? Yeah, that makes you feel good, warm and fuzzy inside. You're like, Astros are winning and I got 44.2A on my side. But this is what happens if you make your relevance, hearsay, non-responsive, argumentative objections. Boo. Other errors, so non-constitutional errors, these are your rules of evidence errors. Any other error, defect, irregularity, or variance that does not affect substantial rights must be disregarded. And that, yes, is a picture of trash. It's garbage. Relevance, garbage. Trash, garbage. Garbage, trash. So we're not going to be those people, are we? I'm on a mission now. I gave this speech at the Regional Capital Public Defender's Office. You know, and these people, they all do death penalty work. They've been doing this a long time. They're like, why is this crazy chick coming here to talk to us? But I changed their lives, or at least a few told me I did. But anyway, this is what I want to inspire you to do, and I want you to be thinking about what you can do. Thinking about it, planning about it. You know, Mark puts 0 hours in planning his opening statement. I really appreciate that. I would like to add there, I'll take 30 minutes of you planning for your appellate hickey. We'll just put that in there. Like, what can I do if I lose this case to get it reversed? Right? Wouldn't that be fun? Isn't it fun to win later? It's that delayed satisfaction. I can live off a win for about 5 years. I'm not kidding. All right. So the judge won't let your evidence in. You make a bill. Are you going to forget to make that bill? No, because you know why? It really does scare the judges. It really does. They're like, oh, this lawyer is trying to do something that might get me reversed. I don't like that. Put your evidence in the record for appellate purposes. Have it ready. And then put on the record why you need it, because otherwise it would deprive your client of due process. That's right. Fair trial, the whole bit. When in doubt, so you're like, I don't know what to say. And I understand that. You know, you're warriors out there on battle and nobody is on your side. You're defending Nazis. I mean, George's speech earlier, and that was the third time I've heard it, but I cried again. It's like, oh, I'm defending Nazis sometimes. But when in doubt, Constitution, your precluded evidence, why you needed it, and how your client was denied a fair trial. Can you do that? I want to see a shake of heads. Yes, I can do that. All right, has anyone got an updated score? I'm kidding. All right, but I hope we're still ahead. All right. What is it?